Today we're going to be talking about a very important topic to data protection and privacy law, one that many organizations struggle with because it's pretty vague. The concept is pretty vague, but to which there shouldn't really be significant issues in undertaking. We're talking about DPAs or DPIAs rather, and conducting effective DPIAs because they don't only need to work to comply with applicable law, they need to work for your organization as well. So to get started, let me share my screen. Which you should be seeing shortly. Okay, great. So my screen should pop up now. What I want to say from before we actually dive into this is please, if you have any questions, comments, concerns, pop them in the chat and we'll address them as we go along. This session is for you to engage with me, to ask questions, and to figure out how you can enhance your data protection journey. So, what will you get from today's session? We'll define DPIAs. We'll look at when you need to do them. We'll look at a few DPIA templates as well as types of DPIAs. Then we'll consider the consequences of not completing a DPIA when the law requires, and also when your compliance framework may require. And then we'll dive into a bit about the living DPA or the living nature of a DPA. So to get us started, what exactly is a DPIA? There are various definitions out there that I've come across, but really the sole purpose of a DPIA is to not purpose, but rather the definition is it's a process to identify the data protection risks of a project. Many DPIAs often extend beyond that to both identifying and mitigating the risks of the project. But in my opinion, it sort of dilutes the whole function of the assessment, which is really to create a snapshot of those risks. Visualize taking your mobile device and taking a picture of something, and from that picture being able to understand what it looks like and provide a description of it. Risk assessment and risk assessment and risk mitigation only comes afterwards, and so I think it's very important not to conflate those. And then the purpose really is to ensure compliance with data protection regulations, but also manage the privacy risks of your project that you're working on. And typically, the key components of a DPIA include identifying data processing activities, assessing necessity and proportionality, and sort of mapping the processing activities against the lawful bases for processing, but also the conditions for processing. On papier, it would be conditions in most data protection laws across the world. It will be focused on principles. And then there's documenting findings and managing risk associated with them. So you'd often hear of privacy impact assessments as well. So it's different than a DPIA. Based on my research and my experience in conducting DPIAs and privacy impact assessments for organizations. So if you think of it this way, let's look at it from a South African perspective. Our constitution guarantees everyone the right to privacy. And then part of that privacy rights includes information privacy, and and it has been confirmed in local case law that the right to information privacy includes information security, or keeping information secure, or protecting it. And so there are different layers to this assessment. This assessment is focusing specifically on the data protection elements of a project. Privacy is much broader than a DPIA, and so privacy impact assessments are much broader. And just for clarity, in a South African context, we typically go, the regulator, information regulator, has referred to it as a personal information impact assessment under the regulations. I think it's the, let me just check. Yes, it's the 2019 POPIA regulations. So, moving along to our next slide, when do you need to conduct a DPIA? And this is an interesting question that I often get asked. And really, it's when the law requires, or when your organization's approach to data protection compliance. So in your data protection policy, not your privacy policy, your data protection policy that sets the standards and guidelines and compliance levels that your organization adheres to. When they indicate, all three of them individually indicate that you would need to conduct a DPIA, then you would. In South Africa, the criteria really is that whenever you are processing personal information, you need, for a specific project, you need to conduct a personal information impact assessment. And under POPIA's regulations, that's the responsibility of the information officer. So it's really for any data protection project. In a GDPR and European approach to data protection law, DPIAs really need to be conducted whenever there's a high risk to the individuals, or where there's a significant amount of sensitive data involved. You can check that out in Article 35 of the GDPR. But over time, what has emerged is criteria for when to conduct DPIA, and aligned with the global approach to data protection, it's large-scale processing of sensitive data, when there's extensive profiling of data subjects, or if public areas are being monitored, for example, by CCTV footage. However, again, that is the global approach. The local approach is whenever there is a project that you're working on from a POPIA perspective, you need to conduct a personal information impact assessment. I've provided a few examples over there, but essentially it really depends on your organization's data protection policy and your approach to compliance that you're taking, ranging from absolute compliance, where you comply with every area of every part of data protection law, to minimum compliance, where you only do what you need to do to avoid getting a fine or going to prison. Please keep the comments and questions coming. Okay. Next, we will look briefly at the DPIA templates. And so here I'm specifically referring to a template that you can rely on to conduct a DPIA for your organization. Now, there are thousands of, or maybe even hundreds of, or tens of thousands of DPIA templates out there. But the most popular templates are the ones from the ICO, or the Information Commissioner's Office in the UK, which you can have a look at. But really, from an organizational perspective, to conduct effective DPIAs, you need to standardize them. And standardization consists of various elements, but typically what it includes is adopting or producing and adopting a DPI template that works for your organization and that you use consistently, or relying on a vendor that supplies data protection software that will provide those DPIAs that are customizable to your organization. But often those data protection software, in my opinion, is pretty costly, and most organizations, even enterprises, tend to rely on Excel spreadsheets, Google Sheets, to conduct DPIAs. I know it's not ideal, but we need to look at the reality that organizations' budgets are tight, and the primary objective is not to use a fancy solution. It's to get the DPIA done in the most secure way possible. But typically, a key section or the key sections of DPIs include, well, what is the project that I'm involved with? How is data flowing? So mapping those activities. Then, if you decide to do so, you could make your risk assessment part of that, and we'll get into the risk matrix a bit later. But that would be to risk rate those processing activities. So for each activity, let's say you are developing an AI-based solution to decide to grant insurance policies en masse. So low cost, high volume transactions of insurance policies. And you want to use AI to evaluate candidates for insurance. One activity would be a data subject uploading their personal information and documents to your platform that will allow them to provide you with information to make that assessment, right? And so when we're looking at how the data is flowing, we're looking at specifically from whom it's coming, to where it's going, and where it's going to be stored. And so data would flow in that way. And really, depending on the nature of the flow of data and who has access to it, that will influence the risk rating that you essentially give that specific activity. And it will influence the mitigation measures. Lastly, on the DPIA templates, I would say that please don't reinvent the wheel, but at the same time, ensure that the DPIA speaks to your organization's specific needs. So you need to strike a balance between standardization and customization. Because you don't want to have to conduct a comprehensive DPIA rather on a project that doesn't call for it. And we'll get into the different DPI types soon, but for now, it's just to know that there are light touch DPAs versus comprehensive DPIAs. Okay, so now we'll be looking briefly at the risk matrix. This risk matrix typically forms, or in one form or another, forms part of the DPIA process. And really, it's once you know what your processing activities are, you've mapped your data flows, etc., you would need to add a risk rating to each of those. So the ICO has come up with this risk matrix, which you see on screen now. And really, it's to look at the activity and balance and compare the severity of the impact on the data subject to the likelihood of harm materializing. So it's a probability exercise. What's vital, though, is that each of these decisions that you make based on this risk matrix or the risk matrix of your organization needs to be documented. You need to document the decisions you take, because if anything goes wrong, or a regulator comes knocking on your door, you can justify why you made certain decisions about certain processing activities. Okay, great. Next, we'll be having a look at DPIA types, and we'll look at it from different angles or perspectives. So you get light touch DPAs, well, we're talking about complexity now, so you have the light touch DPA. It asks basic questions. What are the processing activities involved? What are the what are the processing activities involved? What are the types of personal information involved? Who is the responsible party or controller? And who is the operator or processor in this transaction? And that really is to give you a TLDR, too long didn't read, version of the DPIA. So it's pretty light touch, and it's typically used at the beginning of a project to give you a cursory understanding of the impact of that project from a data protection perspective. At the other end of the continuum, you have comprehensive DPIAs, which consists of several questions that need to be answered, consists of mapping of processing activities in detail. It really is essentially a well, I mentioned a picture. A DPIA is like a picture. visualize this as an entire gallery of pictures of what has actually taken place. And really, the complexity of the DPIA varies depending on the nature of the project involved, for example. Okay, another angle to look at this from is really, so DPIA is very based on customization needs. So you would need to, depending on your sector, tailor the DPIAs to the risks inherent within your specific sector. So if you are in the healthcare sector, you would naturally need access to highly sensitive, special personal information, healthcare data, for example. And the risk in the healthcare sector in particular is that that data could become publicly available and be subject to severe security compromises. And so the DPIA would need to be sector specific. Again, I'm not saying reinvent the wheel, I'm saying rely on your sector specific bodies that could produce a template DPIA. You could reach out to international bodies as well. There should be various, well, from what I've seen, various research companies that specifically focus on identifying and finding these DPIAs. You could also have a look at the IT Lawco website to download the templates that are available over there. Other examples include financial services and retail, as well as direct marketing. The types of data typically involved there are, well, I wouldn't say predictable, but I'd say you'd be able to identify them more easily. And then, yeah, as I've mentioned, they are sector-specific guidelines. Now, the third perspective that I want to look at DPI is from the perspective of the stage of the project that you're in, the stage of the project life cycle that you're in. And so you'd have your standard DPIA template, which your organization would use, ideally speaking. Then you'd have this preliminary DPIA, which I mentioned, the light touch one, where you need to decide whether you need to conduct that complex DPIA. So you need a snapshot of what is happening. Naturally, because data protection laws haven't been here forever, sometimes you need to conduct retrospective DPIAs. Although it's not recommended, I don't personally recommend that you wait to conduct a DPIA. This is in the case where you have multiple projects on board, some of them that you may not have even been aware of, and you realize, oh shit, we've missed out on this. We need to actually ask a few questions about this project. It's pretty sensitive from a privacy perspective at first glance. So you would need to conduct a DPIA retrospectively. And there are examples of retrospective DPIAs out there. If you need any templates, feel free to pop me a mail. And then lastly, and this is typically when you are sharing data between controllers or responsible parties. So you have joint controllers or co-responsible parties, and really they may be involved in collaborative projects, and there may be a data sharing agreement between them. But they would often, if their projects would impact their stakeholders, they would need to conduct a joint DPIA. I haven't come across many organizations that have done this. I've conducted maybe 7 or 8 of them, but they're not popular within South Africa in particular. But I think they will become more popular as data flows become more significant between organizations, especially within specific industries as well. Okay. Now let's look at the consequences of non-completion of a DPIA. And really, here there is the potential globally for regulatory fines. There have been significant fines in the EU within this context. Locally, from our regulator, where the regulator has issued enforcement notices, you would specifically notice that those notices set out action steps for organizations who are non-compliant that they need to take. And essentially, those action steps include conducting a personal information impact assessment and what would happen if it were not conducted. Then there are also the regulatory repercussions. So as many of you may know, although data subjects can rely and contact the information regulator to complain about an organization's approach to privacy, that isn't its only remedy as a data subject. Data subjects have the ability to approach a court to ask for legal intervention. What I've typically seen is it manifests as interdicts to stop processing. It also manifests as claims for damages. So, and that really your contracts are important within that context, and your documentation in order to have an overview of that. Then there's a reputational damage, and this seems to be the most pressing concern for many enterprise organizations, that they will lose the trust of their customers and other stakeholders. And so they typically involve PR agencies in this context. And then there are also the unidentified operational risks. Now, an angle that many organizations often don't consider, and in consulting with various key executive roles like CIOs, CTOs, CISOs, and executives responsible for digital transformation, as well as the chief operating officer of an organization, what I've come to understand is that most organizations aren't connecting data protection and their data assets to their business continuity. And it's a very niche area. Not many people know how to do it, but the gist of it is that in order for your business to continue, you need to meet the compliance requirements. And those relate to your data assets as an organization. And for your organization to continue, it often needs, well, all organizations really need to rely on data. And so if a data subject would interdict you from processing specific types of data, or it would be a class action, for example, then it could significantly impact your business's continuity. And so data governance, data management, data security becomes a significant operational risk, and thus influences your business continuity. And so that definitely needs to be considered within that context. Then the last part that I want to chat with you about is the living DPIA. And really the fact is, although a DPIA is a snapshot at a particular moment in time where you identify the data protection risks of a specific project, the DPIA is not meant to be a dead document. It is meant to be living. It's not meant to stop at a certain point. It's meant to be updated as time, as the evolution of time goes on. And so really they need to be updated to reflect changes in the regulatory environment, to manage new or ongoing risks, to understand whether anything within the project specifically has changed, so that the DPIA accurately reflects the status of your project, and then also to sort of set periods. So what I normally recommend to organizations is that from a privacy by design perspective, to ensure that privacy is considered at each stage of the life cycle of your project, that DPIAs need to also be a deliverable that is conducted as part of your general, let's say, software development projects or data projects that you have within your organization. And that really ensures that, number one, there's privacy by design, but also that it doesn't fall through the loop. And there are ways to equip the different teams in your organization with the skill set to look at a specific project and, from a cursory level, at least identify privacy risks, so they could transfer or refer it to your information officer or the other body responsible for managing risks within your organization, such as your GRC teams. But that is the gist of today. If there are any questions, feel free to let me know. Otherwise, I don't see any questions in the chat. That is it for today. I hope you enjoyed the session, and I look forward to seeing you again soon.